right, ladies and gentlemen, so there is a witness for the defense, Jose. She's a friend of the defendant's. What do you think exactly the defense was trying to get from her, and did they succeed?
I think they did succeed because they established that there were behavior by the defendant that exhibited mental illness, exhibited unusual tendencies, things that were not normal. And that's exactly what's going to play into their conclusion that this was a person suffering from mental disease or defect. This was a person suffering from battered child syndrome. She felt sheltered. She couldn't be independent, self-sufficient. And that's exactly what you wanted the jurors to hear, is that type of inadequacies and tendencies of the defendant.
Yeah, I agree with you wholeheartedly. It's interesting, the prosecutor tried to come back around and say, well, you can do these things, but don't you think that's a double-edged sword?
Yeah, I didn't know where she was going with that line of examination. Comparing one and two is like apples and oranges. I think that the jury is going to see past that and say, well, my kid is different from this person on the stand, and she's different from the defendant. We're all different. Especially
if she has a mental disease or defect. It certainly, I don't know, that might have been a little bit chancy.
Yeah, I thought that she probably was best served asking less questions.
Yeah, always a difficult thing for us lawyers to do, shut our mouths. Okay, guys, we're going to take a quick break. We'll be right back. All right, ladies and gentlemen, since we've been in court, we have a new guest here with us. Michael Bachner is a criminal defense attorney. We are still here with Jose Nieves, and we are talking about this case. There's been an objection as to relevance, Michael. Is it an appropriate objection?
The answer to that is I didn't hear the full question.
Okay, what do you think, Jose? You think it was inappropriate?
Absolutely. I think that they're going way out of the range of what's reasonable here. Yeah. Getting into the grandparents' education, the mother's education. I think that we if you want to create an environment of what was happening with this defendant, that's one thing. But to go through the background of each relative, I think is not relevant.
Yeah, go ahead.
Yeah, now that I've heard the question, thanks, Jose. When you're doing a psychiatric, when you're doing something based on mental illness, the environment of the entire family situation can be relevant to try and determine what the background was, what the family environment was, et cetera. So while I agree generally relevance is in the discretion of the judge, when you're doing a mental health defense, judges, I think, should be a little more inclusive.
Well, and that's probably what they're talking about here in the sidebar now, right? The defense is probably arguing, well, our expert, who they're going to hear from, is going to say X, Y, and Z about this background, this biology, this nature, nurture, all of those things together. And then the prosecutor, of course, I love having one of each here with me at the Law&Crime Network. It's like I can put you to fight and I can leave. But the prosecutor is going to say, come on now, what are we doing here?
Yeah, we have to determine what the mental state of this defendant was at the time of the crime, and that should be very small realm of evidence and information. Anything beyond that is just confusing to the jury.
Yeah, I mean, it definitely is getting into some detail there, Michael. She was asking about the grandmother's education and visits to the grandmother. There's also a little bit of, and I don't know if it was posturing or what, but a little bit of her like, are you okay? Do you need a tissue at one point or something like that? Trying to it didn't seem to me like he was getting emotional, but sometimes lawyers do that, right? They try to point out when there's some emotion to bring out some sympathy in the jury.
Right. To see if the witness is being affected by their testimony, if they're saddened by it or anything like that. And I think it's all theater, courtroom theater that can be avoided.
Trial is theater, right, Michael?
Yes, and jurors don't like to be played either, and they're very, very sophisticated. So you got to make sure that if you're doing the theater, you're not going to insult the audience.
All right, ladies and gentlemen, we're going to take a quick break. When we come back, we'll be right back in that courtroom. All right, ladies and gentlemen, another interruption, another objection by the prosecution here. Remember, this witness is on for the defense. He is the uncle of the defendant, and he's testifying about his relationship with his sister and whether or not he was really involved with her relationship with the daughter. I want to bring in my guests, Michael and Jose. I'll start with you this time, Jose. We've had another objection. Where do you think the defense is trying to go here, and why do you think the prosecutor is trying so hard to stop her?
What the defense is doing is trying to paint the victim in a bad light, to say the victim was making these poor parenting decisions, she was controlling, overbearing, and that's a very dangerous ground to walk on for a defense counsel when you have a double homicide I think that, the prosecution is right in trying to curtail it and bring it to what's relevant and making sure that we don't get into a victim bashing session here.
What do you think, Michael? I'm sure that you take an opposite approach, so let's hear.
Well, they don't have much to lose. This is an insanity defense. No one's defending the case on its merits, and their view is if we can we only need one juror in a case like this. If we can hang it, terrific, and if we can get the insanity, wonderful. And I think it's just, their view is it's important for the jury to know the full gamut of the relationship.
Yeah, and the judge quickly decided that sidebar, so let's go back to the courtroom and see what's going on. Ladies and gentlemen, there was an objection. It went to a sidebar. I'm not so sure the defense is in the right with this one, so I'll let our defense attorney speak up to it. She's objecting because she doesn't like his tone.
Well, she didn't like his tone. She was trying to argue that he didn't lay the proper foundation to impeach on a prior inconsistent statement, saying that his testimony really was not inconsistent with the information they were trying to impeach him with. So it's really kind of a technicality. It can throw a lawyer off when you get something like that, but I don't know how much you get out of it.
Yeah, she hasn't done much. Michael, you said something when we were off air that I want to make sure that the audience heard. What did you think of her direct examination?
I heard a lot of motive, but not a lot of defense. So far we have someone who's, gives a lot of motive maybe to angry child, but I didn't hear anything about crazy yet.
No. Jose, did you, are we missing something?
Not at all, not at all. I think that the testimony was really based on or focused on whether the parents were good parents, whether mom made good decisions, and I think that is way far afield from what we should be looking at.
Yeah.
I mean, if they were abused, then they should have brought it out.
Yeah.
And you got to remember, jurors, they're all parents. Some are good parents, some are bad parents.
Right.
Some don't kiss their kids a lot. Some don't hug their kids a lot. They don't want a bullet in the back of the head.
Well, that's right. That's right. It's an interesting technique, and I kept waiting for something. I kept waiting for some sort of smoking gun. But it was clear from the beginning that this uncle hasn't had a lot of interaction with the two of them together. We're going to take you to a quick break, ladies and gentlemen. We'll be right back and back into that courtroom. All right, guys, so I want to bring you back in briefly, and that was one of the friends of the defendant called by the prosecution. How harmful is it, Michael, if you've got a defendant whose friend is called during the prosecutor's case, just for the whole tone of that to the jury?
Well, you're always looking, and juries are told to look at the credibility of the witness. Do they have a motive to lie? Do they have a motive to fabricate? And you call someone who you would think would be on the side of the defendant, and they're there being called and telling it how it is. The common sense that a jury weighs says, well, the credibility of this witness seems to be intact. Now it's just a whether, does it make sense? Are there things of that nature? So it's calling a witness like that is obviously better for the prosecution.
Yeah, it's a good idea, even when, as here, Jose, it wasn't like it was like a real strong, blazing gun in that testimony. Do you think that was purely for, as you mentioned before, the trialist theater?
Yeah, I think that's right. I think when you bring in a witness that has no interest in the outcome of the case, has no axe to grind, and they just basically tell you what they saw and heard without any passion or anything like that, it has a lot of credibility to it. And if it adds to your case, then that's just one more piece of evidence you can add to it and say you heard from everyone that you could have possibly heard from.
Right.
And they all told you what they saw.
Yeah, it's each pearl on that necklace for the closing.
Exactly.
All right, ladies and gentlemen, we're back live in the courtroom, so we're going to take you straight there. From a motto, but we're going to talk a little bit, go back to Nachtman for just a second, because I do want to talk, Michael, you were pointing out some of the things that maybe you would have done differently with that uncle witness. Tell us a little bit about that. And then, Jose, I want to hear from you how you might have countered it.
Sure.
I think we may be kind of on the same page on this. That witness actually, I think, ultimately could have been a much better prosecution witness than a defense witness. And you could have established merely by asking him to repeat his testimony the motive that she had for killing her parents in a very normal type of way. That is, there was anger, she was upset, she didn't like the way she was being treated, she was nervous about her parents, with the computer, but that's kind of normal conduct as well. There was nothing about his testimony which indicated to me that there was any abnormality in her conduct, nothing. She saw, I would have asked him, did you see anything abnormal? Did she ever act in a way? And I think his answer would have been no, because he certainly never reported any type of conduct. And that cross-examination by the prosecution was, I may not have asked any questions rather than ask some of the stuff he did and just let the jury know that this guy said nothing.
Jose, if you're the prosecutor in this case, would you have thought about calling him in your case?
Oh, no. No, the way he was performing on the stand, I would not have called him on my case. I think we could have established probably that type of hatred towards the parents or animosity or anything like that through other witnesses. And I really believe that this witness didn't have enough contact or interaction with the defendant to establish that. I think as a prosecutor, if you want to establish something, you want to make sure that the witness comes in with competent knowledge, personal knowledge, and can say, on these dates, this is what I saw, this is what she said. It was a lot of, I think,
right, my
impression. And I think that's weak testimony in itself.
Yeah, and that's why we saw so many objections to relevance and all those other
speculation,
things. Yeah, absolutely.
Relevance.
Absolutely. All right, ladies and gentlemen, there's been some other interesting witnesses in this case, and specifically the defendant's brother had the chance to testify. Let's take a look at that testimony. All right, guys, I want to bring you back in just briefly. That testimony, no matter how you cut it, is gut-wrenching. This poor brother. It's interesting, Jose, that brought in a little bit more of not just motive, but there's blacking out involved. There's some being told to do it, or that she felt like there was a sign that she hadn't finished the job. Who do you think that testimony helps?
Helps the defendant.
Yeah.
It establishes a mental defect. It establishes some type of mental breakdown that caused her to have a lapse in reason.
Yeah.
And I think that helps her. I mean, she's trying to say that she didn't understand the gravity of her actions, and when you're hearing things like that, it plays into that.
Michael, you mentioned, I think it was off air, but the importance of, we still have to hear from a psychiatric expert. That person is going to really have to tie everything in for the defense and wrap up a nice bundle for the jury to hang their hat on, right?
Right. To prove a mental disease or defect, generally speaking, I can't tell you that I'm sure of that jurisdiction, but generally speaking, you have to show the defendant did not appreciate the wrongfulness of the conduct. Kind of, they used to be the old, what we call the McNaughton rule, the difference between right and wrong, but that's kind of been made easier. It's just appreciate the gravity of the conduct or the wrongfulness of the conduct. So the fact that you're maybe a little crazy, that's not enough. I mean,
right.
You've got to actually know that what you're doing was not appreciate the wrongfulness of the conduct.
And that testimony in that respect doesn't do much to help the defense. It's going to be really interesting to see what the experts have to say in this case. But before we do that, we do want to know the rest of this person's testimony and the piece that we have. So let's take a look at that. All right, ladies and gentlemen, before we go to a quick break, I do want to bring our guests in, Mike and Jose. I just keep going back to what you said earlier, Mike. It just seems like they're just establishing motive, and there's no mental disease or defect, no testimony to say that she didn't know what she did was wrong. And in fact, don't tell mom. That's like the basis of it, how every one of us grew up. Do you think, I'll start with you, Jose, do you think that this is it's all the defense has to work with?
Yeah, I mean, you do the best with what you can, you have, and the facts, you can't change them, you can, get better facts, and they're doing the best with what they have. I think that it's true that, maybe they're painting a background for the expert testimony, but right now, it doesn't look very favorable to the defendant. Now,
is there anything they're seeing here, Michael, that you would do differently?
Well, I would be focusing more on trying to really establish what the mental break is, having your kid, when they say made her get liposuction, I don't know if that, are we going to call the doctor now to see what her behavior was there? Maybe she was thrilled to get it. I don't know what her reactions were. I don't know what the prosecution's response to that is going to be. Getting liposuction, getting some type of cosmetic surgery it still doesn't smell to me like something where her behavior was motivated by a lack of appreciation of the wrongfulness of her conduct yet.
Yeah, I agree. And add into it the fact that it wasn't in the heat of any sort of emotional moment. And it really puts the defense in a tough position. And maybe this is all they have to work with.
When we look at the Menendez brothers' bar about the level of, of their alleged craziness when they shot their parents.
Right.
Sexual abuse, real aggressive conduct that they alleged. Right now, it doesn't smell that way here, but things could change. We don't know.
Yeah, and as you pointed out before, they only need one juror, so we'll see what happens. We're going to take a quick break, ladies and gentlemen. When we come back, we have all these cases to talk about, so stay tuned. All right, ladies and gentlemen, we have heard a lot more, none of it really establishing what I think we've been looking for all afternoon. I want to bring my guests in one last time with me to talk about, really, Jose, what they're doing right here is exactly what you said, which is getting into the custody battle between the deceased woman and the father. What do you think the defense is hoping for here?
Maybe it's an attempt to try to establish an isolation of the defendant away from people who love her, away from her own family, and that was part and parcel of the abuse that she was, exposing the defendant to, an isolation. I could see maybe where a closing argument can be made from this testimony, where bit by bit she was isolating the defendant.
Yeah, and I think I think, Michael, that sort of comes upon your point, which is that instead of this huge issue, it's going to have to be a drip, 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 drip type of thing, and the expert's going to be really important to tie that together, right?
Yes, and I think the fact that the brother also went through he ran away, he didn't feel comfortable at home, establishes that this is not just some type of horrible environment for her, but it was sufficiently bad that a 15-year-old runs away as well. So I think it's corroborative of whatever she was going through. It maybe just affected her in a more gross fashion than it did him.
Yeah, it's, we're in the defense case, and the defense still has to call their expert. What are you hoping to hear from that expert, Jose, that will help you in your closing briefly?
As a prosecutor?
Yes.
As a prosecutor, we just want to hear whether there's a basis for their opinion, and whether they can actually point to certain images or certain episodes in the life of this defendant that led to her decision to kill someone.
Michael, I'm going to have to not allow you to answer that question because we're running out of time, but I'm sure
Mike.
Aaron will give you a chance to do that.
Sorry, my life.
Ladies and gentlemen, Aaron Keller will be in this seat with these gentlemen in just a few minutes, so be sure to stay tuned here at the Law and Crime Network.